that printed out.
Hello, everyone. I'm so sorry that I'm late. So I hope that we're going to just try a share screen. If you can tell me that you can see my screen.
And wonderful. Welcome, Marg. We thank you for coming on, Deanna. Thank you so much for your insight while we were getting going here.
I can't hear anyone.
Okay, so we can see your screen, Marg.
Sarah, I can't hear you. Can you hear me? Okay. Can you see my screen? Okay, then let's get started, and I won't hold anyone up any longer.
Just
1 minute.
So I'm just gonna just quickly, guys. So we do want all of your questions. I know if you're like me, you have a million questions about TRESA. So we do have the Q&A box open for any questions that you're throwing in. We're going to be saving most of these till the end because a lot of it will be covered as we're going through everything, and we want to make sure that we have enough time to put all of that in. But please feel free to throw the questions in as you're thinking about them. So again, that Q&A box at the bottom of your screen, throw in your questions. We will make sure that we get to all of them to make sure we are all ready for this Friday. So I will let Marg take everything away. Thank you so much, everyone, for joining us today, joining the Jennifer Jones team and Marg Gourlay from OREA. Okay, so
thank you so much, Sarah. And once again, I'm so sorry to have held you up. I could not hear anything that you said. So obviously there's some tech issues. I'm going to proceed. Please put into chat, just as you did, if there's a question that you would like me to try and answer. So everyone, how I would like to start. This is not RICO. This is not OREA, your brokerage. This is an information session today, and it's from the provincial government, and through OREA, we get to have the information. But TRESA, everyone, is the Real Estate and Business Brokers Act being amended and what's going to affect our industry as of this Friday. So it's wonderful that I can get to be here with you right now. What we all need to know about trust in real estate services as it's going to impact our industry. So this is who I am, everyone. And you see that FRI, and that stands for a fellow of the real estate industry. I have been a realtor for well over 40 years, everyone. I am a broker of record and certainly going to be impacted by everything that you're going to be impacted by as well. I have obviously loved my real estate career for many, many years. I have been a member of the OREA TRESA task force for over 3 years. And what an experience as we saw the changes coming and how we could look at it from the realtor's point of view and take back comments to the provincial legislature. However, I must just bring to everyone's attention, nothing in this information session, and as Sarah has told me, a live webinar, is to be taken as legal advice, everyone. This is information, and our regulator, RICO here in Ontario, is going to be responsible for enforcing all of this compliance within our industry. So through that, everyone, starting December the 1st, can you imagine with these changes? Please don't anyone be nervous. This is going to take a good 3, 4, 5, 6, 7 months to evolve into our practice as we are dealing with our clientele in the future. So let's look at the presentation format for today. So it's going to be a summary of what we've already encountered. And phase 1 of the amended legislation was actually entered into March of 2020. So REBA amended. One of the amendments to REBA is the name change. TRESA And it's literally, everybody, TRESA 2002, just like Rebo was. But that year has nothing to do with it. It's about the legislation coming into a current level. So in March 2020, there were a couple of things that changed. We'll just have a brief review of that. What we can expect in phase 2, it's beginning December the 1st, Friday, but it will take time to roll in. And then if we can, a brief mention of what we can expect in phase 3 to be introduced in 2024. Now, December the 1st, 2023, and this date, everybody, will not be changed. We all know, and I'm sure lots of you have had discussions about what's coming and how it was pushed back from April the 1st of this year. But this is it. The forms are getting ready, and lots of you will have the opportunity to go to the Wednesday webinar from Maria with standard forms as that is outrolled to everyone. So December the 1st, here we go. As we proceed, everyone, if any of you have questions, you can see I've just circled oria.com/TRESA. Please take advantage of keeping this website handy as things may challenge you and you want more information. And it's just for you. Just get the questions answered. Many times here you're going to see frequently asked questions. So the TRESA background. Let's start with, everyone, when you and I have been in real estate for a very long time, and maybe some of you a short time, we all knew the contracts we worked with, the listing, the buyer rep agreement, or any other contract, in the name of the brokerage, under common law and agency law, the brokerage was the agent. But in our industry, nobody understood that. They always spoke about the person they were working with as, Sarah's my agent, Dina's my agent, Marg's my agent. They didn't say ABC Real Estate is my agent. So updating information, everyone, includes bringing compliance up to, in consumer protection, to how the consumer speaks. March 2020, we were entitled to, in advertising, call ourselves a real estate agent. Previous to that, that would have been non-compliant. Today on our cards, our signs, our social media, you can use the term real estate agent. And if you're in good standing, of course, with your provincial association and CREA, you could use the term realtor. So that's one thing that was introduced in 2020. The other one is the first point here, everybody. When we look at what happened in 2020, was that we were entitled to form personal real estate corporations. Some of you may already have done it, taking advantage of using tax planning with your business income and getting some advantages if you've taken the time to do that. For many of you, maybe a wonderful idea. And for lots of us, it may not be the right thing to do, and that's fine. So that was phase 1, everyone, the new descriptors for registrants and being allowed to create a personal real estate corporation. I've owned my own corporation, everyone, for many, many years. And my brokerage corporation has a limited liability. Please note, if you do form a personal real estate corporation, there is no limit to your liability. That's not part of a personal real estate corporation. So my advice would be, please speak to your own accountant and or your own lawyer as you decide whether this is right for you or not. And then as we come into phase 2, the key changes to our business practice. The first thing I'm going to speak about, everyone, is the relatively updated code of ethics in this legislation, the elimination of the term customer, disclosures, and what our responsibility will be today, how we're going to use the information guide that is being produced by the Real Estate Council of Ontario, how RECO, the Real Estate Council of Ontario's discipline committee, is being strengthened. One of the new pieces of practice will be the sharing of content of offers and who's directing that. The contents of written agreements and how our agreements may have changed. And tomorrow, if you go into the standard forms seminar, everyone, with Cassandra under standard forms, tomorrow at 1 o'clock, you're going to see lots of the written agreements, but I'm going to bring some issues to your attention and the why. And finally, the issue that held up the date for us this year, we're going to speak about designated representation and how it can impact our real estate practice. So as I said, the Code of Ethics. Right now, everyone, the Code of Ethics under the existing Real Estate and Business Brokers Act is 13 pages long. In it, there are all of the sections of the code that you and I have to comply with. But there's all kinds of technical issues and procedural issues. So in the wisdom of updating, they have taken technical and procedural issues out of the existing part of the legislation called the Code of Ethics, and they have put it into another chapter, let's call it, of this legislation called the General Regulation. The code today, and you can easily print it off, everyone, is 2 pages. It is brief and concise. These are the issues that you and I must comply with in the delivery of our service to the consumer in Ontario today. And it is about integrity, the quality of our service, and any conflict of interest and how it must be handled. So it is literally bringing it into more ease for the real estate practitioner and understanding for anyone what is the issue that I have to consider in a particular situation. So that leads me to self-represented party. And if it's okay, I'm going to often say an SRP, just because it's quite a mouthful. So under REBA, we always would meet consumers and we would have the opportunity to invite them to be a client of the brokerage and yourself. And we could offer them, if that's not what they wanted, customer service. Not representation, just customer service. Well, with the new legislation, everyone, the term customer completely removed. There will be no customer service, and the introduction of the term self-represented party is what will occur under TRESA. So it's really understanding how does this work. I'm sure lots of you have actually encountered people that through real estate, they don't want our help. And they'll say, I don't want to sign anything. I know what I'm doing. I don't really need your help. I just want you to show me the property. Today, if you meet that party, it's fine. It's their choice. They're saying they don't need any of our guidance, our expertise, our opinions. They know everything themselves. After we have given them RECO's information guide, and they have had it explained to them, they've acknowledged receiving it, but they've still chosen to represent themselves, we would give them another document, and I'll go into that in a minute, acknowledging the risk. And this person that's going to represent themselves isn't getting anything from me. I'm only going to look after my client. So you can see in red under the stack of papers here. They're acknowledging that self-represented party isn't new, it's just being itemized today. So let's define what this self-represented party is, this SRP. It's a party that is not a client of any brokerage. They're not under any type of agreement with any brokerage. And you can see in the italicized part here, 13.3.1 is literally right out of the legislation. I'm going to read this one. A brokerage shall not enter into an agreement with a buyer or a seller for the purpose of trading in real estate, unless if the agreement does not include the provision of representation. Bottom line, no representation, that's it. You're looking after yourself. So when you're representing a client, I've got a really great listing. Assistance can be provided to this person that called me up and said, I see your sign, I'd like to see the house. Even if they've chosen to be an SRP, because I am serving my client, I am looking after them, I'm helping them market their property, get the very, very best price for their property. So this SRP that wants to see it, they've chosen to look after themselves. They know I'm not looking after them. They know I'm looking after my client. I can show them the property, but watch what it says. I cannot let that SRP rely on anything I said, no experience, opinion, judgment, or advice. When I show them the property, I can give them fact. That's it. Anybody can have facts. If they want facts about the neighborhood, I can give them facts. But if they said to me, I see that house next door just sold, what did it sell for? I can't tell them that. It hasn't closed. It's not a fact. The bottom point, as service to the registrant's client, assistance can be provided to that SRP after this SRP has received the information guide only prepared by RICO, and the SRP is presented with a self-represented party acknowledgement form only prepared by RICO. So this party that knows it all is really well informed. And if I ever met this party, it might be a lawyer. They just wanted to see the property. They're going to write up their own transaction. Maybe it's a registrant from British Columbia. They're not registered to trade in Ontario, but they know what they're doing. They're going to look after themselves. Maybe it's a builder, developer, someone with so much experience. They have people that's going to put together their documentation and paperwork. It's not going to come from me. I'm showing them my client's house. I'm looking after my client. So let's go look at some questions that were often asked. So one of the questions that we have, or one of the issues that we always have to look at, and I'll just go over this part first. The self-represented party acknowledgement form always brings to this party's attention that the brokerage represents the client, just as I've said. An explanation of the risks that may arise from the party representing themselves when they're receiving assistance from a brokerage that's representing somebody else. A description of the type of assistance that I'm permitted to provide. A recommendation that the parties seek independent professional advice. And that could be a lawyer, could be another brokerage. However, please note number 5. The regulation does require or requests a signed acknowledgement. And you and I know that we'll meet people that'll say, I'm not signing anything. So what do? I'm going to, at this point, just remind everyone, TRESA is on the shoulders of the real estate professional. It's not on the shoulders of buyers or sellers. We must prove that we have complied. So I would certainly be doing this acknowledgement form and presenting it to this party that wanted to look after themselves. I would ask them to sign it. If they ever said not signing anything, if I was dealing hard copy, there would be a line diagonally through it. It would be dated, and I would have said this party has declined to sign, even asking them to initial that comment if they would. If not, so be it. If you're doing everything online, everyone, amazing notes detailing the circumstances of what you're dealing with, and I want notes that could always be retrieved. In the industry, we want to have proof that we have complied. This is not about, we're not going to make buyers and sellers do things that they don't want to do. But I don't want them to put any of us into a non-compliant position. So keeping that in mind, some of the questions that are asked when we're doing this, and I've brought up the RICO bulletin, everyone, dealing with the self-represented party, and what kind of assistance we can provide to this person that is looking after every concern themselves. Because you and I know how to look after clients. They get all of our fiduciary duties. But let's look at number one. Can I show another brokerage's listing to this person that's told me they want to be a self-represented party? Well, if I could talk with you or hear anyone, the answer is no, everybody. Because another brokerage listing is not my client. And the only time I can assist this SRP is in service to my client. Number two, if a buyer chooses to be self-represented, wants to make an offer, should I write up the offer for the SRP as a service to my seller client? Well, we could have a really good discussion on this one, but I will, since I did hold you up, give you a best practice. If anyone ever asked me to assist them in putting an offer together for them, I cannot imagine a circumstance where I wouldn't be giving them answers to their questions about the types of conditions, about me filling out a form on their behalf. There's so many issues that I would be bringing just in my practice to that person's attention, including precise about the legal address, about the lot sizes. I'm giving experience. I'm giving advice. I'm giving know-how to this person that wanted to represent themselves. I'm not allowed to do that and remain in compliance with TRESA. So, SRP, go see your lawyer. Let them write up the offer for you. Bring it to me at noon tomorrow, and I'll take it to my seller client. Okay? But I know how hard many of you work to generate business opportunities. What about this? If the SRP wrote down price, deposit, closing date, always want to know if I can get the financing. And I said to them, well, look, I'm going to talk to my client about what you've mentioned. My client may want to ask me to assist them to put an offer together that will bring it back to you. Could we do a seller's offer where I can counsel advise, give expertise, and give caution to my seller, could I do a seller's offer back to the SRP? Yes, I could. The very best thing, everyone, is inviting and bringing to the SRP's attention the benefit of being a client of yourself and your brokerage. However, lots of people make their own decisions. If a buyer inquires, I'm on number 3 now. If a buyer inquires about my brokerage listing, but is not interested in the property, yet I know of another brokerage's listing that may be of interest, what can I do? So I'll bet on your websites, any kind of social media platform, everybody, and any of your efforts to generate business, you always want to give as much as you can to generate the possibility of earning commission or remuneration as we speak about it today. And what a better way than in meeting someone from your existing marketing efforts, that's not the run for them, but keeping them to you to go on to show them other properties. Well, this is a very, very different world today. If they're not your client, you're not doing it, everyone. You have an opportunity to invite the SRP to become a client, such as they want to see another property. Great, I'm entitled to show that to you. If you would like to take advantage of us treating you as a client and giving you our very best service. And this is what you would sign. Again, I don't want to sign up a long time. We are privileged to have a RIA that has created forms that we are entitled to use. Tomorrow you will hear about a new limited services representation listing or client agreement, where we create the representation and we can take this SRP, turn them into a client, maybe just show one other house. That limited service may just be for that one property. You are protected, your brokerage is protected, and we have complied with TRESA saying we really can only look after someone that we represent. And that's the issue, everyone. Other than that, we cannot show an SRP somebody else's listing. So in proceeding from there, there probably are some questions, and I will answer them, and that would be through Sarah's guidance. But we'll do it at the end if possible. So what it means for us, everybody, only client or self-represented party as we go forward December the 1st. When representing a client, assistance can be provided to the SRP as a service to or incidental to a service to our client. But it must not encourage that self-represented party to rely on the registrant's skill, knowledge, or judgment. Self-represented party is not a name change for customers. Please keep that in mind. And you can't collect any kind of remuneration, another word for commission, from an SRP. That's why RIA has created this new limited services agreement, creating representation where we can have limited service and create a client that may satisfy that SRP to be under contract with our firm for a short period of time. You could also use this limited services one if there was a FSBO for sale by owner, or if you wanted to work with a seller under limited services. So there's some wonderful new forms to learn about that will help us through this. And I'm staying on this really just for a minute, everyone. I said, in summary, it means December the 1st. But everyone, if you have a customer service agreement, and let's say it started November the 20th, and it goes until January the 20th, this is just hypothetical, you will proceed that way. You will complete your existing contract. On January 21st, we're not entitled to offer customer service to that party. So as of December the 1st, this becomes what we must comply with. But if you're under an existing contract, customer service contract or representation contract, you will proceed under that contract until it expires. Day after expiry, you can only offer the type of service that TRESA enables us to offer. Let's go to disclosures, consents, and acknowledgements. You and I have been doing this for years in real estate, everyone. There are many, many disclosures throughout the Act. Some will remain the same, some have been slightly revised, and there are some that are new. In the case of disclosures, TRESA is saying in having well-informed consumers that they want that word disclosure prominently placed. That's why they've highlighted it in blue here. Any kind of disclosure we make, any kind, must be in plain language that's clear and concise so that the consumer well understands it. Presented in a way that brings attention to the information that is to be conveyed. So just as a reminder, we've been doing this in multiple representation, conflicts of interest, direct or indirect financial benefit from a registrant's point of view, material facts, latent defects that the seller knew about, an SPIS, excuse me. We've been doing lots of disclosures. But have we been doing them in time so that people were well informed prior to making a decision for a finalized contract? And there's some of the things that will change everybody is our timing. You've got the RICO bulletin here about the summary, but it says everything I've just said to you in those bullets right there. And I'm going to bring up this timing of disclosure in multiple representation as an example. So here we go. This is the new form you can see on the screen, not in effect until December the 1st, 2023. You can read it. It says multiple representation, seller acknowledgement, and consent. So there's a number of stages I have to speak to here. Please bear with me. I want everyone to picture the listing agreement or the buyer rep agreement. In that agreement, we have that paragraph called multiple representation. When someone signs a listing or signs a buyer rep agreement today, they are not agreeing that there's a multiple representation circumstance that exists or that they consent. They are acknowledging in signing it that they have the information. This is how multiple representation is done. This is what it is. So when they sign the listing or sign the buyer rep agreement, they're just informed and they're acknowledging they have that information. So under this legislation, we are being told, all of us, that we have to bring to every party's attention that's in this transaction as soon as we are aware that there is a multiple representation situation, that it exists, and get their consent. So you know what, sometimes it's the easiest I can do is with an example. You have a marvelous listing. Great. and you actually have a buyer that's really interested in it, and you've shown the property to your own buyer, and the buyer says, okay, I want to put an offer in. And we get the terms of the offer together. This is a buyer client, and we're putting that offer together. That buyer and that you know that in this situation, multiple representation will exist. The only person that doesn't is the seller. This form, there's one for buyer, there's one for seller, has to be done at the time it begins. So the buyer would sign their form, and they're acknowledging that they know when they put an offer on this property, it's going to be multiple representation, and they understand how it has to be handled. And they consent. So we've got that done. But before the offer is sent to the seller or presented to the seller, we cannot proceed until we get the seller's consent. We've sort of done this with the confirmation of cooperation and representation, but it's always been done at the time of the offer. And today they want it done prior to that. So the parties that are the decision makers, the seller and the buyer, they can say, yes, I will consider working in multiple representation on this particular transaction. So it's a new form, everyone, 325. Multiple representation, there's one for buyer, there's one for seller, but it's the acknowledgement that in this particular circumstance it exists, and it's their consent. So I'll just go over the bullets, everyone. Disclosure requirement for multiple representation are not new. The timing of the disclosure is important. That's what's going to be vigilantly observed, certainly in any inspection, and the dating. And please don't for a minute, everybody, think of backdating anything. It's just, it always comes out in court, everybody. Someone says something, it's wrong. Just do the disclosures when we're supposed to. Timing is an issue. So while a representation agreement might make a client aware that multiple representation could arise, and that's what I've said, listing or buyer rep agreement, it does not represent a disclosure of the fact that it has arisen. And the client's acknowledgement that the situation might arise does not represent the client's consent to working in multiple representation. As soon as the brokerage is aware that it is in multiple representation, it must make a full disclosure to each of the clients. The brokerage can't take any further steps on behalf of any of the clients until the disclosure is made and a decision has been made whether they consent and it's in writing. And it's what you and I need to prove compliance. So many times people will say things to me like, why all of this? Legislation has changed because of court cases and because of ethical complaints. This is to raise the bar, everyone. We all know our legislation, but it is saying make sure the salespeople, both in your brokerage, the people that you're working with, are delivering compliant real estate professionalism. That's what this is about. And it's because people have been hurt, everyone. So people will always say, why are they changing all of this and doing it? It's bringing it up to current speak. Consumers call the person the agent. It's bringing to our attention what's happened and how we can prevent it from happening again. So the information guide. The information guide is mandatory, everyone, and registrants must provide a consumer with a copy of the information guide and explain the contents. Please note, capitalized, bolded, and underlined before providing any services, before entering an agreement with a client, and before any assistance may be provided to that SRP. Please note the only permitted version of the guide is the one that is prepared by Rico. So the question I'm always asked, well, does that eliminate working with the realtor? Because that's what we've always used. Well, I believe that OREA has done a super job, the OREA Forms Committee, when they have retained the working with the realtor format. Please note, none of the forms at OREA are mandatory. We have the privilege of using them in our industry as compliant nature for our brokerages, everyone. I would have really hated to have had to hire lawyers and create my own agreements of purchase and sale, my schedules, my listings, and all of that. It would have thousands and thousands of dollars. When we have a provincial association that creates these forms that we can use, that assist our brokerage, our salespeople, and our brokerages to prove compliance, we are very lucky. Many of us have been working with the realtor right now to give proof that we have brought to the consumer's attention the different types of service we could offer. Today, working with the realtor, you can see what they've highlighted for you. The very first highlight is saying the, let's say, buyer acknowledges having received and been explained the information guide. It is initialed and it will be signed. It is a tool for the real estate industry to use to prove to the consumer and to prove compliance that we have done our job. But please know, none of this is mandatory. This is good tools for us to use, and because we're accustomed to working with the realtor, you may use it along with the information guide. The information guide, everybody, is, I think, 12 pages long. It can be sent by a link. It can be emailed. If you are dealing at hard copy and you're meeting with your potential client, you're going over with them carefully, it can be done in hard copy. There's always a page at the back. Please acknowledge that I've done this with you. And they would have a copy and you would have a copy. This is an alternate, not an alternate, it's an extra tool for you to use, the working with the realtor. Please acknowledge here that I have gone through this and explained it for you, with you. So I'm just saying it's there for us. So what's in the information guide? First of all, the benefits of being a client of you, of the registrant, the duties the registrant owes to the client, and then, of course, the obligations of the clients to the brokerage, the risks of receiving assistance as a self-represented party from a registrant that's representing a client in this particular transaction. In the content of agreements with brokerages, the information guide is going to say, this is what should be there for you, Mr. Consumer, how long the agreement will last, if there are any termination provisions that clearly will identify what will happen if the brokerage proposes to provide services to more than one client in a transaction. And we all know that's multiple representation. But what happens if a client declines to consent? What can the brokerage do? I've got a seller client, I've got a buyer client. Could we do something else? And we'll move into that in a minute. So can we terminate one of these contracts and offer something else? What's the scope of the listing authority? Have we mentioned what we're going to do? And they want us to do that, everyone. Add a Schedule A to your listing authority or your buyer rep agreement. And it's about, if I'm listing the property for you, if I'm going to do an open house every weekend until it sells, write that in. I'm going to cut the grass, stage it, whatever it might be. Write it in so the consumer and the registrant are on the same page. They all have the same information. Multiple remuneration, of course, we have to itemize. Sorry, I'm skipping that point. Remuneration, we do have to speak about what the seller or the client is paying to the brokerage. If there's any circumstance where that stated remuneration might change, that has to be stated. Multiple representation, and we're going to speak about that and how to bring a concern to the attention of the brokerage or file a complaint with RICO. All of that is in the information guide in some detail. Some of you may already have printed it off. It's been up on the RICO site, then down, and now it's back up again. But you can have a good look at it if you go to that process. I did mention that RICO's discipline committee is going to be greatly enhanced, everyone. And there's purpose for it. And the whole purpose is getting the bad actors out of our industry. The discipline committee is going to have an expanded ability, everyone. They are themselves going to be able to suspend, revoke, or apply conditions to a registration. There will be no more appeals committee at RICO. The RICO, if there's any time that someone wants to appeal a committee's decision, it would have to be taken, and it's in the third bullet, to the Licensing Appeal Tribunal in Ontario, which really is a quasi-judicial body. And there's many industries in Ontario with registration or licensing that if there's an appeal to a decision made where someone could lose their right to earn their living, and this is the only place where you can appeal a decision. Because on a discipline committee of any nature, but certainly in the real estate industry, there must be a minimum of 5 people. And one of those parties, everyone, could not have anything to do with our industry. And it's as if they're representing the consumer. So this is an individual, not a registrant, no connection with the real estate world. And that sort of is saying that the consumer has a voice in this decision making. And then the regulator's power and tools. So RICO, this allows RICO to look into the registrant's conduct and refer a matter to the discipline committee. But please note the next part of my sentence that's on the PowerPoint. Whether there's a formal complaint or not. You and I know for so long it's been anyone was complaining about a registrant must be in writing, must be signed, or they're not touching it. And there was a reason. There was lots of complaints. Today they're taking on the umbrella, everyone, that the discipline committee can look into a registrant's conduct, whether there's been a complaint specifically about that person or not. Sometimes it happens, let's say you or I were complained about, and it goes to the discipline committee. They look at the circumstances and they think those people didn't do anything wrong, but there's something wrong here. And it's really the other salesperson. They can go after that other salesperson themselves. And the issue will be, everyone, the fines have been greatly enhanced. RICO shall also make information about a registrant available to the public, including proposals to suspend, proposals to apply conditions, or proposals to revoke a registration. So that means even before it's actually happened. RICO does have limited abilities to collect transactional data for the purpose of regulatory oversight, as it currently does not have this authority. I'm just moving on. Please write down any questions you may have. Sarah's going to be in control of that. And And I think if the record is stopped, then perhaps I'll be able to hear at the end of it. But let's go on to the next one, everyone. Offer process, how it's changing. Please note at the top of this form, it says seller direction to share substance of offers. Under the new legislation, this seller can say to their brokerage, if we have multiple offers, I am directing you to share the content of these offers. They may think it might shorten down the time to get to the price they want or enhance what they might get, and they want to direct the brokerage to prepare for this. So there's a couple of things here, everyone. Let's start with the bullets. The barrier to sharing the contents of competing offers will be removed. I'm jumping down to the bottom. Of course, no personal information may be disclosed or any other information that would identify the person making the offer. Nothing personal. We come up to the middle. This new process permits the sharing the substance of competing offers if the seller directs. They're actually giving it to you right out of the regulation. I'll go to B, General Regulation 22.7. If the seller directs to share the substance of the competing written offers, please note, and it is bolded, it must be with every party that has made an offer. It's not just with the top two. That's how this is to be done if the seller wants to do it. So everybody gets the information. 2, for the purposes of Clause 1, the seller could also direct that they only want to share parts of the offer. So if you can see the form clearly enough, there are circles beside the word price, deposit, conditions, closing date, other. Let's go take a listing. When we are sitting with the seller to do this, we are bringing to the seller's attention that there is a new option in our marketplace where, should they want, they would be able to share the content if they had 4 or 5 offers sitting in front of them. But they must direct us, the brokerage, to do so. We can't just do it because we think it's a good idea. We need it in writing to prove that we've received the direction from them. There could be a seller that says, I don't like that. Let's just do it the way we've always done it. Just forget that. Fine. Now I'm going to go over to the buyer side. Because this is allowed, from now on, all buyer reps working for their client would want to bring to buyer's attention the seller today may decide that they want to share the content of your offer with other parties should there be multiple offers. I just want you to know this before we start putting your offer together. So now we've got the two sides. The seller can decide to do it or not to do it. The buyer is informed that this process exists and we'll go forward. There might be lots of buyers that, okay, well, I get it. But if somebody gets my information, I get their information, right? And they're very okay with all of this. Because in that dance of negotiation, everyone, even if the seller sends back the price on all 5 offers and the buyers all get it, nobody knows what any buyer is going to put back in. Buyers can walk away. They could improve their offer. They could leave it the same. They could diminish their offer. Couldn't they? It's just the buyer has information. how they handle it, they may want to discuss that with their real estate professional. But everyone, there could be a buyer, just a little bit like that first seller that says, I don't want my information shared with anybody. So somehow, I want to offer on that place, but I don't want that seller to share my information. Or RIA is creating and has created a clause for us to use that the buyer rep may put into the buyer's offer, where it says that if the content of this offer is shared, this offer is revoked. It's an action, like your irrevocable date. So bear with me. You've got a buyer, don't share anything. You put in this clause, and there's 4 other offers, okay? 4. So now we got the 5 offers. One of them wants confidentiality. They all go into the seller. The seller has previously said to you, I want to share price and deposit on all of the offers, so I quickly get parties coming back with the very best they can do. So we got 5. The seller looks at all of them. He wants to proceed with sharing. So be it. The offer with the confidentiality clause really is quite interesting to the seller. Now, nobody has signed anything. The seller rep will say to all of the other cooperating reps, I have 5 offers. You know that's a disclosure that we have to make. In creating a document that says offer 1, $1 million, offer 2, $1,010,000, offer 3, $1,015,000, offer 4, $1,050,000, offer 5. Everybody gets all that information. So nothing about that offer 5 has been disclosed. The other 4 offers, their information's been shared. Everybody got everything. Everyone got the true number of offers. And the seller can still entertain any of the offers should they come back. 2, 3 offers go away, 2 offers come back. One of the offers that came back was the one that had confidentiality clause or the irrevocable clause in it. Nothing was ever shared. It's the best offer. So be it. That offer stands or was accepted and signed. The seller could still participate with consideration on that offer because he didn't disclose anything. If he had, the buyer could. If people were told about the information in that buyer's offer, that buyer can walk away. Well, of course he can, because nobody signed anything to make it an agreement. So keep in mind how that dance actually works, everyone. But what happens if that seller that said, no, I don't want to do that? Fine. Your smart cooperating buyer reps, you've told your buyers it might happen. When you get to presentation, there's 6 or 7 offers, and the seller changes his mind. We better get this Form 209 signed. If it wasn't signed previously, it has to be signed and initialed now. Just reminding us, TRESA is on our shoulders. It's not on the shoulders of the buyers or sellers. They can change their mind at any time. Contents of written agreements. Caution to us, written agreements must clearly, comprehensively, and prominently set out the following on all of our agreements. Case of a listing, remuneration payable to any other brokerage. Circumstances where that could change, such as multiple representation or assisting an SRP. Can we talk about that with our seller? What's going to happen? They want it in writing at the beginning of the relationship. Services that the brokerage will provide, and I mentioned that already, be it staging, cutting the grass, showing one property to a buyer and just having that one property shown to them, or a FSBO and having a limited service agreement where I'm showing your property to Mr. Red Sweater, and if Red Sweater brings you an offer, you're agreeing to pay. That's the limited representation and service that we're providing. Terms related to termination, if any. Now, already on our agreements, if any agreement is longer than 6 months, we've always asked the client to initial. Today, every single expiry date will be initialed. Doesn't matter if it was 24 hours, 2 weeks, 6 months, all expiry dates. And of course, our contracts would have only one expiry date. And that leads me, everyone, to our last bit, and that is a designated representation agreement. So this one will probably take a minute. Please bear with me. I'm going to have a drink. Excuse me. So let's look at our listing agreement. And of course, this would always go for our buyer side as well, buyer rep agreement. But right now, let's look at this listing agreement. There will be one listing agreement, everyone, and in it, there can be a designated representation. There's some real good benefits with this, everyone. If you look at the bullets, and that's where we'll start. Permits a brokerage with multiple clients in the same trade to designate a different agent to fully represent each client in a trade. So this isn't a seller's choice. This isn't a buyer's choice. This is a brokerage choice. Permits a brokerage with multiple clients in the same trade. It allows each agent to deliver services in the best interest of their respective client versus the limitations that occur resulting from multiple representation. But how do we fill out the form? As you can see on the screen, they've got a listing form here for you. When you and I take a listing, we use the information, and if the seller initials in exclusive, this will remain an exclusive listing with our brokerage. If the seller initials MLS, this exclusive listing will now go out on our MLS system. So it's the same way with the next steps I'm going to take you through. It's how it's filled out. So the brokerage owns the listing. It's the way the world works in real estate in Ontario. So this is between the brokerage named and a telephone number and the seller who's named. This is the seller of the real estate property. Then you see the term designated representative. Under that, I hope you can see it, it's in brackets. Name of salesperson, broker, broker of record. So let's say your name was put here by the brokerage, meaning you put it there, right? So under that it says the listing agreement is a designated representation agreement where the brokerage has designated, let's say the salesperson, as the designated representative and or S, it can be 2 people or a team or 3, whatever. And all parties understand it is the designated representative or TIVs, watch this, who will be providing services and representation to the seller. And the brokerage will provide services, but not representation. It depends how you filled out this form, everybody. If someone's individual name or names of salespeople are there, this becomes a designated representative form listing. If it's not filled out, it stays a brokerage listing. When it's a brokerage listing, everyone, under common law, brokerage is the agent. We know that. I'm going to try and do this so you can see my hand. The salespeople in the office are the set of legs providing the service on behalf of the brokerage, who's the agent. If there's designated representation, the salesperson themselves becomes the representative for that particular client. Nobody else in the brokerage is representing that seller. The whole brokerage, everybody else can provide services, but they're not providing representation. So what does that mean? Watch this. I've got a listing. You're in the same brokerage with me. I've got a couple of open houses I have to do this weekend. I need someone to help me do an open house on one of my listings. So I contact you. Can you help me out on 123 Blue Street? You said yes. You can do that open house for me. And you may generate some intake of business opportunity because you were good enough to help me service my client. But it's only me with the confidential information, understanding the motivation of the seller, their financial needs. That's not you. You don't talk to my seller like that. The brokerage will still be administering the paperwork, still providing trust account obligations and full accounting, still monitoring all of the administrative staff, providing services so this seller's property can be marketed through the brokerage. But there's only a designated rep that's really representing them and taking care of them and knowing why they're selling or buying. And then we proceed on, everyone. So with this, you can see what's going to flow out of it when we talk about that term, representation. Under designated representation, the service remains with the brokerage, just service. The agency relationship is between the consumer and the named agent. That designated representative is the agent responsible for promoting, protecting all the best interests of the client, while the brokerage and all the other salespeople or agents in the office are objective and impartial. The designated representative is also responsible for protecting the confidential information of the client. This means confidential information such as the client's motivation to buy or sell, such as the client's financial circumstances, and it can't be shared with anybody else in the office. Multiple representation will still exist if all parties consent in writing, and I'll go there. I'm going to step back for a minute though. Let's say there's a team and it's a husband and a wife. And for years, they have cultivated a wonderful real estate practice. As a matter of fact, some of the people that they assist with their real estate are their good friends. Both the husband and wife have been named as the designated representatives. They have so much information about their clientele, everyone. It would be very hard to take it out of their head. So let's step into what happens with this multiple representation. I guess I better just go back. It's not there. Okay. So if each salesperson in the office has their own client, so If I had a client and you work for the same brokerage and you were a designated rep on your buyer's agreement, your buyer wants to put an offer on my client's house, we're not in multiple representation any longer because each of us are just looking after our client. We do not have the conflict of confidentiality or full disclosure. Very straightforward. That's wonderful. And in large brokerages, what a break to minimize that horrible conflict of multiple representation. How on earth do you really work for two bosses? Difficult. That's why consent is so necessary. But let's go back to that husband and wife team. You know, they've worked for years. They've built up an excellent clientele, got a good listing. Subsequently, one of the buyers that they've worked with for years and would be the client actually calls them and says, you know what, I saw your new listing. I'd really be interested in seeing it. And once again, the husband and wife are that buyer's client or designated rep. So now the husband and wife and the husband and wife, they have a client that's interested in one of their own listings. That's where you might see multiple representation and where you must get the consent. So it can still happen, even though with designated representation, many times it will now be eliminated as salespeople just look after their own client. So in summary, everyone, the implementation date is December the 1st, but it will take months based on existing contracts or understanding how we deliver this as it rolls into our industry. When I first met you this afternoon, and I know it was rushed, I said to you, I've been in real estate a long time. I've been in real estate prior to Reba coming in, prior to working with the Realtor being introduced, prior to buyer brokerage being introduced. Anytime there's a change, everyone, we all sort of have to get used to how do we incorporate it into our professional real estate service. So this is to note that the new code, everyone, is only 2 pages long. It's my suggestion for anyone that wants to have it handy. If you're looking at different circumstances, print it off, have it where you can always see it. It's very, very specific. These are the sections. This is what we must comply with. 2 terms under TRESA. We will only encounter client and self-represented party. No more customers. Consumers were confused about that and what it meant. And the reason they were confused, everyone, is most real estate people that I've met are wonderful people persons. And they tended to look after the customers just as if they were a client. But that wasn't okay. Assistance can be provided to that self-represented party as a service to or incidental to a service to our client. But it must not encourage that SRP to rely on our skill or our judgment, our advice, our knowledge. We can give any consumer fact. But please know, the house that sold last night that hasn't closed is not fact. The SRP must be presented with the statutory self-represented party acknowledgement form. It's prepared by RICO. We want to have them acknowledge that they have received it and understand the risks. Disclosures must be attention drawing, written in plain language, and be presented in a way that brings attention to the information that is to be conveyed. Registrants must provide consumers a copy with the information guide and explain the contents. And this will be quite a reasonable conversation, everyone. And it is the one that is prepared by RICO. And even if you work for a commercial firm and you're accustomed to having all of your own documentation, even an agency disclosure document, which was our residential working with realtors. Depends if that's what you did. As far as the information guide goes and the acknowledgement form for the SRP, doesn't matter what type of real estate you're in, those are the forms that must be used. The barrier to open offers has been removed. Designated representation allows each agent to deliver services in the best interests of their respective clients versus the limitations resulting from multiple representation. And finally, everyone, I guess I have taken too much of your time. Please visit aria.com/TRESA. There's some good videos there. There's frequently asked questions. And tomorrow, it's going to be really neat to be part of the forums webinar Wednesday, and look at all of the new forms that we will be entitled to use. This is the team that's been presenting the new provincial legislation in the province. We ask you to remember that website. And at this point, you could, if there's a question that anyone has, I'll do my best to answer it if I can hear it. On top of that, everyone, I just want to say thank you. So you know what, Sarah? I'm going to put down the share. If you want to stop the recording, it may let us talk. I don't know.
That was such great information there. I'm just going to, I think it's...
How can I improve that? If anyone can tell us, that would be wonderful. Now streaming. I think it's the volume on your computer. All right, let's look at that.
All right, guys, thank you so much. Again, while we're waiting for
volume on
Marg,
the computer.
But we can go through. I see some questions that are already in the question and answer.
Can anyone help us, or should I just look in chat? I know you'll have lots of questions. I can see more. Here's got 9 Q&A.
Yeah, so we're going to go through and make sure that we get to all of these guys. So if you have more questions, throw them in that Q&A box, and we are going to get those read out and answered.
Can you, I can't hear. Should I just go from this? Sarah, you can nod. Should I just read them out and see if I could answer them? Would that be satisfactory? Okay. Please bear with us, everyone. I'm so sorry I can't hear you. So if I put this down, can I see this? Here we go. All right. So I've got, if we are working with our client seller and the buyer is an SRP, what happens to the cooperating commission? Oh, that's an interesting question, Wendy. Wish I could see you. There's no cooperating. There's only a listing brokerage. So I'm not quite sure what that would do for you. Does that make sense, everyone? There's only a listing brokerage. There's no other brokerage involved. So you're probably going to be working twice as hard if you're creating a seller's offer back to an SRP, or they've gone to their lawyer, they've had a lawyer drop the offer, and carefully going over that with the seller, giving them the time to go to a lawyer to perhaps look at it if it's on a different document. Because you know we can't give ARIA forms to anyone. They are under copyright. The only way that lawyers get to use them is if they've bought a license to use them. So Wendy, I hope that answers your question adequately. The issue is there is no other brokerage involved. So I'll pull this up. How does agency rep work within a team? I don't understand that question. How does agency rep work within a team? If I have an idea of what you're saying, how about this? If there's a team, I'm going to use 8 people. So if the agreement was, I'll put that one back up. I didn't see. So in chat. No, I can't see that.
Oh, guys, I am chatting.
On a team, everybody. Sarah, bear with me, please. You could have, let's say, 2 people from the team as the designated representative of the seller. So right now, everybody else is just part of the brokerage providing services. A buyer comes along, there might be one person on the team as a designated rep of that buyer. If that buyer came in and put an offer on the listing, there would not be multiple representation if it was those two entities. I hope that clears that up. Okay. If we're working with our client seller and a buyer is, what happens? Okay, we've done that one. How are we avoiding offers that do not protect the buyer properly? How are we avoiding offers that do not protect the buyer properly and would possibly, if accepted by the seller, not go through due to the SRP buyer not understanding the clauses needed and not protect? Okay, wow, what a question. We're not protecting an SRP at all. They want to go to their lawyer and pay a couple of $1,000s to have the offer put together. Their lawyer will be protecting them. If we went to our seller and with advice to our seller, we would say all of the things that you've put in the question. Don't know his financial circumstance. We should consider this. Would you be interested in working with giving this other person a seller's offer back to them? And depending on market conditions, the seller may say, yeah, but look, let's start with a really good deposit. And then I want even more because we're going to let them have 5 days to find financing so that I'm assured with natural steps in this transaction, I have more and more confirmation that they're going to close. And you and I know, just because REBA's changing, we still have all kinds of pieces of legislation that we have to work with. FinTrack, PEPITA, all of those things. And if anybody was bringing money to the brokerage, I got to tell you, all of that FinTrack is done. That doesn't stop. I don't care what position they want. Can I nod to me if that's an okay, if we're getting there? Okay, Sarah, thank you. So I'm with Dina. Sorry, delete that. Okay. I'm at Mary. Yeah? Is that a nod? Okay. If we need another agent on our team to do an open house for us, do we need to put them on as a designated party and get our seller to sign it? The brokerage provides services to every seller that they have got under brokerage contract. The parties that are representing are the ones that are named. So somebody else on the team could certainly do an open house in providing a service. But what they couldn't do, and the designated reps would prepare the seller. Now look at, I'm the party, or we're the party that's looking after you. You're going to leave. We have someone that will hold this open house for the public. Please come back at such and such a time. And we would have cautioned that other salesperson, that's that brokerage entity, we would have cautioned them and said, look, you're not getting any confidential information from my seller. You're not speaking to my seller because that's outside of the realm of what you're entitled to do. I hope that makes sense. Okay. I'm going to, which one? Wendy? How are we avoiding offers? Okay, I've done that. Are we okay there, everybody? Am I keeping looking, or am I going to, where would you like me to go? I'm under Wendy. I've got a content. Is this the information guide I have to show my client starting? Tomoko, I'm not sure. If it's on the RICO website, it's called information guide, so that would be correct. If we're holding an open house on a property, it's not our listing. Buyer clients, if a sale that discloses they have an agent, Is it correct to say that we cannot provide them any information except what is, that's the same, always the same. You don't provide anybody else's client anything other than fact. Any consumer can have fact from you. They can get it on any site they even go to. Do we still need the RICO and free guide sign? You're not working with them. You're not ever working with somebody else's prospect. Guides at open houses and buyer. Please follow the policy of the brokerage that you work for. It's so important. Brokerages are developing procedures and policies that will be in your best interest. Great questions, Wendy. How does agency rep work within a team? I think we've answered that. Oh, Angelique, thank you very much. Okay, Dina, let's say we get an online lead who wants to see a listing, not ours. We send them the guide and they sign it. This doesn't stipulate whether they want to be a client or not. When do they have to sign the buyer rep? Well, as soon as you start working with them. You don't take out people without knowing what position they would want to be with you. They may want to still decide who they want to work, of course, possibly depending on how we get along. So when you're caught in a situation like that, what can you do to overcome the stumbling blocks? Follow the brokerage policy. One of the neat new forms is that limited representation. And if they say, well, I'm not sure, you can say, I am entitled to show you that other brokerage listing when you would like to be a client of my brokerage. But I know you don't want to be tied into us for a long time. We've just met each other. So what happens if we agree to meet? I'll show you that property, and our agreement, our contract, will only be for the day that I show you that property, 24 hours. If that satisfies you, then yes, I'd love to show it to you. Period. It's about professional service and how it's handled. Sarah, I think that's probably a good stint on it. I'm very conscious that I've gone past the time. Okay, thanks everyone.
Are so
Bye-bye.
good. And for everybody that your questions didn't get answered, we would advise, again, reaching out to your brokers, reaching out to your broker of records. There is a lot of changes coming in with TRESA. Marg also had mentioned that if you're going on the AREA website, you're going on RICO, they do have a lot of bulletins. RICO especially has a lot of additional information and scenario examples on what to do, what this means. But when in doubt, always talk to your broker of record, talk to the people at your brokerage that have really dug into this legislation and have all of the information to make sure that you're not only protecting yourself, you're protecting your clients, you're protecting the general public, anyone that wants to be an SRP. So thank you so much, everyone, for joining us today. Thank you so much for your patience at the beginning and dealing with the technical challenges that we've had. We are all in the same boat with dealing with these changes coming in on Friday. And at the end of the day, this is going to give consumers, clients, the general public more options. And we will learn through this together and figure out the best path forward. Thank you so much, everybody. We appreciate your time and have a wonderful rest of your day.